Hello, and thank you for joining us for the American Constitution Society for this webinar concerning the Equal Rights Amendment. This event is co-sponsored by the At-Large Chapter, the Connecticut Lawyer Chapter, the Michigan Chapter, the San Diego Lawyer Chapter, the Austin Lawyer Chapter, and the Minneapolis-St. Paul Lawyer Chapter. Thank you to everyone who worked on putting this panel together and promoting this event to you all. We really appreciate your attendance today. I'm Lee Robleski. I'm an attorney at Legal Aid of Nebraska, and I am an at-large board member. It's my pleasure today to introduce our distinguished panel. Kyle Langvart is an assistant professor of law at the University of Nebraska College of Law and a faculty fellow at the Nebraska Governance and Technology Center. He is a First Amendment scholar who focuses on the internet's implications for free expression, both as a matter of constitutional doctrine and as a practical reality. His written work addresses new and confounding policy issues, including online content moderation, tech addiction, and the collapse of traditional gatekeepers in online media and 3D printable weapons. His most recent major papers have appeared in the Georgetown Law Journal, the Fordham Law Review, and the George Mason Law Review, and Lawfare. He received his BA in philosophy from Earlham College, where he graduated with college and departmental honors, and he received his JD from the University of Chicago School of Law. After law school, Professor Langvart practiced at the Chicago, Illinois office of Locke, Lord, Bissell, and Lydell, LLP. He went on to teach as a lecturer in the Department of Business Law at Indiana University's Kelley School of Business, and later as a professor at the University of Detroit Mercy School of Law, where he received the James T. Barnes Sr. Memorial Faculty Scholar Award in 2019. Julie G.Heysuk is a professor of sociology, political science, and liberal studies at the Graduate Center of the City University of New York, and a visiting professor and senior research scholar at Yale Law School. Prior to joining the Graduate Center, Professor Suk was a law professor for 13 years on the faculty at Cardozo Law School in New York and taught as a visiting professor at the law schools at Harvard, Columbia, University of Chicago, and UCLA. She has lectured widely in the United States and Europe and has been a visiting fellow at the European University Institute in Florence and Luis Guido Carli in Rome. She has a JD from Yale Law School and a doctorate philosophy and politics from Oxford University, where she held a Marshall Scholarship. Professor Suk is the author of the 2020 book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment. She is a frequent commentator in the media on legal issues affecting women, including the Los Angeles Times, Boston Review, the New York Times, the Washington Post, Bloomberg Law, Vox, and CBS News. And Catherine Baker is a distinguished professor of law. She's an expert in family law, particularly in the modern law of marriage and parenthood. And she has written extensively on sexual violence and misconduct, especially in the lives of young adults. Her work focuses on the intersection of women's intimate lives and the law. Professor Baker's articles have been published in numerous journals, including the Harvard Law Review, Yale Law Journal, University of Chicago Law Review, Minnesota Law Review, and Boston University Law Review. She is also the author of Family Law, The Essentials with Catherine Silbaugh, and numerous book chapters. Baker is a multiple award-winning teacher, having taught contracts, property, family law, evidence, gender and the law, sexual orientation and the law, environmental law, and numerous seminars on feminism. She has also developed and taught several novel experiential courses designed to prepare law students with non-doctrinal skills that they need to be successful professionally. From 2001 to 2010, Professor Baker was Associate Dean for Faculty Development at Chicago-Kent. She has visited at Yale Law School, the University of Pennsylvania Law School, and Northwestern Law School. Prior to joining Chicago-Kent faculty, Professor Baker was an attorney for the Department of Justice and a law clerk to the Honorable Edward R. Becker of the United States Court of Appeals for the Third Circuit. Assistant Professor Langvart will start us off with an overview of the ERA, and then Professor Suk will discuss some possible impacts of the ERA, and Professor Baker will wrap up by discussing potential pitfalls to consider. We would invite you to type any questions you have for the panelists in the text box, and we hope to have time at the end of the panel discussions so that I can read those questions to the panelists at the end of the presentation. And with that, we are ready to begin. Professor Langvart.
All right, well, thanks, Leah. I want to say here at the outset that I'm myself not a subject matter expert on these issues with the Equal Rights Amendment. I'm mainly a First Amendment person, but I teach constitutional law generally, and there's just so much interesting stuff going on with the ratification process of the ERA and what's going on in Congress right now, that it was just kind of hard not to notice this issue. So I wanted to give kind of a brief overview of what the ERA is about, what the history is here, maybe leaving some more room for our more expert panelists on that stuff, but then maybe also to propose some broader questions about how the mechanics of adopting the ERA might work, what the consequences of those processes might be, and also if the ERA does become the 28th Amendment, how will that interact with the existing constitutional law of gender? So, the original draft, or the kind of precursor to the ERA, the Equal Rights Amendment, was drafted by the suffragists Alice Paul and Crystal Eastman. The thought was that after the 19th Amendment extended suffrage to women, that the natural follow-up would be a kind of extension of the equal protection philosophy beyond matters of race and into matters of gender. At that time, the Equal Protection Clause was understood to apply to racial discrimination, but beyond racial discrimination, it didn't have much effect. And in particular, with gender discrimination, the Equal Protection Clause didn't do very much. Now, later on, Congress actually approved and proposed a draft of the Equal Rights Amendment that I'll post here. And there we are. And you can see here that we have some language here in section 1, equality of rights under law shall not be denied or abridged on account of sex. This language on account of sex it runs parallel to the 19th Amendment. Equality of rights under the law, there's I suppose a rough parallel to the phrase equal protection under the laws, but not exact. One thing that I want to call your attention to is this sunset provision here. And this is what we may be hearing quite a bit about pretty soon. That the proposed amendment would be considered adopted if 3/4 of the states signed on within 7 years of the date of submission. So 1972, we need to move this thing across the finish line by 1979. Article 5 of the Constitution, of course, provides that 2/3 of the Congress propose an amendment, and then 3/4 of state legislatures have to approve that same amendment. Well, initially, the Equal Rights Amendment had broad, bipartisan support. President Nixon supported it. President Ford supported it. President Carter, I guess maybe a little more intuitively these days, supported it as well. And so pretty quickly, there was a lot of movement in the state legislatures on ERA. 22 states legislatures ratified in 1972. 1973, we've got 8 more states. Well, at this point, we're moving along at a pretty good clip. We've only got to get to 35 states. We already are at 30. 1974 to 1977, we get five more states. Okay, it's still looking okay, but it's starting to get a little touch and go. We're slowing down some, but that's to be expected. But in this same time, in 1974 to 1977, we actually see some rescissions. So 4 states rescind. Now the score is down to 31, which is a setback. And then in 1978, the amendment's proponents begin to get a little concerned. Congress extends the deadline by 3 years until 1982. Okay, so hopefully we'll get somewhere with this. And maybe Professor Suk will talk a little bit about Phyllis Schlafly and the kind of politics of backlash that were going on around this. But, even after this extension of the deadline in 1982, we have 0 more states. So at this point, we're still stuck as of 1982 at 35 states, arguably 31 states, depending on how you count these rescissions. And for a long time, the thought was, well, that's just kind of game over. Now, the bright side by this point was that the Supreme Court had begun to extend its interpretation of the Equal Protection Clause to cover matters of gender. Those of you who are in constitutional law right now, or who have just taken constitutional law at some point, will remember that we have this kind of intermediate tier of scrutiny that applies to gender discriminatory laws. And the thought was, well, maybe we'll just let this thing lie. But a few years ago, there was kind of renewed interest in the Equal Rights Amendment, and that picked up more with the Me Too movement. And so there are 2 thoughts about maybe how to get this going again. One thought is, well, we can have a fresh start, redraft the Equal Rights Amendment, maybe update it a bit. The other thought is, hey, maybe Congress can waive these issues with the deadline. Maybe Congress can decide what to do with these state legislatures that revoked their initial votes to ratify. And there's pretty good reason to think that Congress does have the power to do those things, that Congress does have the power to waive the deadline, that Congress does have the power to say that a state's vote to ratify is valid, even if there was a rescission afterwards. And so we start to hear about this 3 states movement. The idea is, okay, we're already at 35. Don't call it 31. Don't worry about the rescinded ratifications. We're at 35. All we need is just 3 more states. And in early 2020, we got there. So Nevada, Illinois, Virginia, the state legislatures signed on. So we're at 38 states. Well, once we're at 38 states, the theory of the case is the ball's kind of in Congress's court at this point, that as long as Congress is willing to sign off on this, waive the deadline, then this can become the 28th Amendment. And pretty recently, the House of Representatives actually did vote on this and voted to waive the deadline. So, some pretty basic questions here that I think Professor Suk especially is going to get into in some more detail. How can this be valid? How can we get past this deadline question? One answer to that, you could imagine somebody saying, well, maybe Congress doesn't have the power to impose deadlines. Well, these days it's pretty clear that Congress likely has that power. The case law in this area is pretty sparse. We have a case called Coleman versus Miller from 1939, in which the Supreme Court said that there's no built-in deadline on ratification. In that case, the theory was that maybe if you don't have states ratify more or less contemporaneously, then it doesn't count as 3/4 of the states voting on something at once. The Supreme Court rejected that doctrine, that these votes have to take place contemporaneously. And of course, we have the 27th Amendment today, which was adopted in the early 1990s. This is an amendment that was originally on the cutting room floor of the Bill of Rights. So at least as long as we agree that that the 27th Amendment is valid, I'm not sure who is going to challenge it. But as long as we agree on that, then it would seem that the Constitution isn't too particular about the timing of all these state legislative votes. Then we have another question of, can Congress count the votes of state legislatures that later rescinded? We have a couple of, or we have one precedent for this kind of thing. Back in 1868, there were a couple of states that rescinded their votes to ratify the 14th Amendment. The Secretary of State at the time ignored them. Congress went ahead and counted those votes in spite of the rescissions. Obviously it's a kind of fluid situation in 1868, but that's a precedent. A kind of larger perspective we could take on this is to say that this stuff just isn't even justiciable, that it's Congress's power and Congress's power alone to decide on these questions of procedure where Article 5 is concerned. So, that's kind of the terrain we're looking at. Now, I wanted to just pose some really general questions about this stuff, because as I said, I'm not a subject matter expert here. First, I wanted to ask whether either Professor Suk or Professor Baker saw any potential for a dangerous precedent in Congress waiving these issues, the passage of the deadline, the state rescission. It seems to me we're playing it maybe a little fast and loose if we waive these things. At the same time, it's sort of hard for me to imagine a situation where somebody somehow games the system based on this precedent. So maybe it's fast and loose, but it's not an especially risky precedent. Second question that I had is, even assuming that these amendment issues are basically non-justiciable, it seems to me that like bubble of non-justiciability can only really go so far. I mean, there's always going to be some point when Congress, I would expect when Congress might decide to sign off on a constitutional amendment and it's just obviously unconstitutional. Let's say that Congress decided to count 32 states as 3/4 of state legislatures or something like that. You could imagine potentially the judiciary intervening. How close to the outside of that zone of discretion are we with these waivers that Congress is looking at? I feel like we're in the bubble, but I could almost imagine the court trying to intervene if it wanted to be aggressive. Third, I'm interested in how the Bostock case attaches to this. I assume that the logic of Bostock is basically portable, and that once the ERA is adopted, that includes transgender protections and protections against sexual orientation discrimination. But I'm interested to see what you think. And then the final question is just, once the ERA is on the books, how does that interact with the existing equal protection law on gender? Does the Supreme Court begin to apply strict scrutiny, for example, based on the theory that that was kind of the mode of constitutional interpretation that was dominant in equal protection law at the time that Congress proposed the statute. Does the ERA somehow supplant equal protection doctrine, or does it supplement? At any rate, I've talked long enough, so I'm going to hand this off now. Thanks.
Great. Thank you for the very thorough overview and the questions that you raised, which are all excellent questions. And I'm going to try to cover a lot of ground, but I just want you all to know that I wrote a book about all of this, We the Women. And I've written several shorter pieces in the popular media as well as in some of the law review literature about many of the issues that Professor Langvart raised. So when I'm done talking, I'll put some of the links into the chat because I'm sure I won't be able to cover everything. But I just want to highlight two really important points. One is that there's a question of why the ERA was needed in 1972 and why it might be needed today, and how that change in light of the landscape of changing equal protection law around gender legitimizes or doesn't legitimize the amendment. So there's a question of the substantive legitimacy of the ERA, given this admittedly unprecedented and idiosyncratic trajectory by which this amendment appears to be headed towards being added to the Constitution, if in fact it succeeds. Secondly, there's the whole range of procedural issues that Professor Langvart did a great overview of. And so I'm going to talk about actually the relationship between the substantive and procedural legitimacy of the ERA. Specifically in 1972, and there's also a backstory of all of the conflicts, even amongst people who identified as women's rights advocates or feminists. For the first 50 years, from 1923 until 1972, there's quite a bit of disagreement amongst feminists, actually, as to whether or not the ERA is going to do much good. But by the time you get to 1972, because of a lot of shifts in the landscape of the constitutional law legitimizing the New Deal and labor legislation, among others, by 1972, there's overwhelming bipartisan and just multi-ideological consensus around the ERA, which is reflected in the vote in Congress in 1971 and 72, where it's not just 2/3. 2/3 is what Article 5 requires, but we're talking like well over 90% of the vote in 1971 and 72 supporting the ERA. And although there's like 10 women in Congress at the time out of 535, equally divided by political party, pretty much all the Republican and Democratic women are in support of the ERA. What they understood, the substantive clause just reads, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Fundamentally, they just wanted to abolish the second-class citizenship of women as it was expressed in various, both federal and state laws. And unequal pay was one of the many manifestations of that, the second-class citizenship. And so, of course, at the time, they wanted to invalidate any laws that discriminated against women, primarily by making a gender classification that was usually based on some kind of gender stereotype about the proper roles of women and men, particularly in the family. And of course, the courts would have power to strike down those laws. But another very important project of the ERA, which I think gets lost in our current court-centric conversations, was that many of the women who advocated for the ERA on the House floor were some of the first women of color elected to Congress, like Patsy Takemoto Mink, first Asian American woman elected in 1964, Shirley Chisholm elected in 1968, first African American woman. And they really emphasized not just that you needed the ERA to get the Supreme Court to wake up on gender equality and strike down more of these laws, but also to empower legislatures. So Section 2 of the ERA, which empowers Congress to enforce by appropriate legislation. And then another provision that no one ever talks about, Section 3. Section 3 says there's a 2-year delay on the effective date of the ERA. And the last time we saw an effective date delay of that kind was actually with the Prohibition Amendment. And it's because the Prohibition Amendment was one where people knew that it required major social transformation. So they knew that you needed to give state legislatures and Congress time to actually write statutes that would be engaged in enforcing the amendment. So the ERA in the 2-year delay was not just like a mere procedural. It was to actually, and it's reflected in the legislative history of the ERA, that both Martha Griffiths, the chief sponsor in the House, and Patsy Mink talked specifically about the role of legislatures, both at the state and federal level, repealing laws, and not just repealing them, because if you get rid of a gender classification, you're not necessarily going to get equality just grow like a potted plant in its place. You often need to put in some kind of infrastructure. So if you get rid of something that actually protects women, then you might need to rewrite something that equally protects men and women, like a labor protection. And that's generally something that courts aren't great at. Courts strike things down. They're naturally shy about rewriting the policy. And the legislative history really reflects this very legislative-centric understanding of the ERA, because the ERA was fundamentally about fishing women out of second-class citizenship. So it wasn't just about getting rid of the bad laws. It was also about being a catalyst for robust policy promoting equality of rights unabridged on account of sex. So with that understanding, and that's the understanding that I think is really important to the revival that we see take place between 2017 and 2020 in Nevada, Virginia, and Illinois. These are 3 states where, first of all, the chief patrons of these late ratification bills, like 40 years after the deadline ratification bills, were African-American women. And I think that also matters for our long view understanding of whether and how this amendment should be legitimized. These are African-American women. And it's so interesting that Pat Spearman, the African-American Nevada senator who led the ratification in Nevada, the first thing she quoted on the floor was actually a Ruth Bader Ginsburg Law Review article from 1978, in which Ginsburg also says what the ERA will do is it'll get the state legislatures and Congress to go through the books and repeal laws that discriminate and rewrite the ones to actually be consistent with equal rights and equal citizenship stature. And in the event of legislative failure, you're going to have courts stepping in, right? So again, this kind of reaffirming of the legislative vision. And what's very interesting about what happens in Nevada, Virginia, and Illinois in 2017 to 2020 is that there is a kind of modernization. There's no question that the Women's March is very proximate and the concerns raised by the Women's March. 2 months later, you get the Nevada ratification, but really the committee hearings are going on January, February, March of 2017. In Illinois in 2018, it's really the Me Too movement and a major task force that's formed in Illinois and a new women's caucus in the state legislature focusing on issues of sexual harassment and violence within the Illinois legislature itself, actually, and how it hinders women from achieving anything in politics or achieving parity in politics. So all of these things, though, as they are forming the backdrop, these legislators do not necessarily understand the ERA as directly getting rid of all of these problems. Rather, they see it as empowering the legislature and giving political legitimacy to projects that are robust gender equality promotion agendas. And they live by their words. In Virginia, also in 2020, you have four African-American, one Afro-Latina woman co-sponsoring these ratification bills. And these legislative sessions, these are women who are, in addition to ratifying the ERA, really doing work on pregnant worker fairness statutes, which draw broad bipartisan support in all these states, statutes that protect domestic violence victims, new state level statutes that protect breastfeeding in the workplace, right? So, and again, and a big through line between the 1970s, this idea of legislative constitutionalism around the ERA, a lot of it has not just to do with inequality in the workplace, but getting at the sources of inequality, which is the disadvantages women face historically and currently because they are mothers. And so there's also a strong discourse about the need for childcare and legislation on childcare in the 70s. And this has really come back, particularly in 2021, because of the experience of the COVID-19 pandemic and its effects on women's employment, particularly around issues of caregiving, because schools shut down, women got displaced from the workplace. Some people say that we're back to 1988 in women's labor market participation, and that might also end up having effects on the gender wage gap and the progress that's been made until recent years on the gender wage gap. So here's how I think that a 21st century ERA could be helpful. That is, we probably do not need the ERA to scrutinize whether you're going to do intermediate or strict. We don't need it to scrutinize sex classifications because the doctrine developed around equal protection and culminating in Justice Ruth Bader Ginsburg's genius opinion in United States versus Virginia is probably enough to strike down gender classifications that are based on stereotypes. She doesn't call it strict scrutiny because by the time Virginia is decided, strict scrutiny has become a doctrine that's used to strictly scrutinize affirmative action in the race context. I think she's very deliberate in the United States versus Virginia opinion to call it skeptical scrutiny. And she buries some footnotes to some of the, like Adirond and some of these anti-race affirmative action cases to point out that sometimes sex distinctions might be acceptable if they are designed to overcome the economic disadvantage of women, for example, but cannot be based on stereotypes or perpetuate the second-class citizenship of women. So, in Virginia, we get that culmination, but this other project, the Section 2 project, empowering Congress, and not just empowering, but almost catalyzing Congress and the state legislatures to do real gender equality policy, I think that's been less kind of like lost. And I think this is a moment because of the pandemic and because of what it will take to fish women out of the second-class citizenship that they're going to experience because of the economic effects of the pandemic on women, especially working mothers, that you're going to need robust legislation. And we're existing in a context where the Supreme Court has actually chipped away at the basis of national legislative authority around issues of equality or even social welfare. So if you think about what the Supreme Court has done to the Commerce Clause with regard to the healthcare case in 2012, it's not really clear that the full range of problems that have economic effects come within Congress's power under the Commerce Clause, right? If not buying healthcare is not commerce, is staying home because you got pushed out of the labor market because of lack of caregiving, is that commerce? And so if you think about the full range of like the full toolkit that Congress would need to actually deal with the complex dynamics of gender inequality, it's not clear commerce will get us there. It's certainly not clear that 14th Amendment Section 5 will get us there because of the Supreme Court's decision in Morrison in 2000, which struck down the civil remedy provision of the Violence Against Women Act. The Supreme Court has taken a very strict view that Congress can really only affect in a congruent and proportionate way things that are judicially determined to be equal protection violations, which focuses on intentional discrimination. So without getting too far into the weeds, it does seem like even Congress's ability to regulate the domestic sphere, violence against women, under 14th Amendment Section 5 is somewhat constrained. Just a few days ago, I've also noticed that some states are now challenging some provisions of the American Rescue Act based on Congress exceeding its spending power. I mean, this is something that's very specific to a tax provision, but I think that the more the Supreme Court chips away at Congress's authority in all these other clauses, the more it's needed for, at least if we're just talking about the female recession, we need a strong statement that Congress has the full toolkit of policy responses that are unconstrained from all the weird ways in which the Supreme Court has constrained these other sources of national legislative authority. So I think that's really important. I'm going to say a little thing about the procedure. I generally agree with Kyle, although we can nitpick about what the actual holding of Coleman v. Miller is. But I generally agree with Kyle that Congress has the power to change the deadline. I think that's consistent with Coleman's understanding that for the most part, questions of timeliness and questions of rescission, whether or not to counter rescission, are political questions for Congress. And the rationale in Coleman v. Miller is that these depend on political judgments, especially the timeliness question, because if a whole generation goes by, Congress has to make a determination as to whether or not the amendment is still needed, whether it's still vital. Dating back to the Prohibition Amendment, the Supreme Court has always said, the Article 5 says that Congress shall propose amendments that are necessary, but it's not a judicially reviewable proposition as to what's necessary. If Congress says it's necessary, right? And so there, it is a political judgment. Do we need the ERA now? We might need the ERA for reasons different from why we needed it in 1972. And so with regard to the second question that Kyle raised, how far does this bubble go? Is the removal of the deadline totally ultra-virus unreasonable? Is it like saying 35 looks like 3/4 to me? And which, you know, would arguably be something that judges should reject, right? Here's the answer to that question. The deadline for the ERA in the slide that Professor Langvard put up, it's in the preamble introducing the ERA, not in the text of the ERA. The deadlines first entered into our constitutional amendment process by way of the Prohibition Amendment, where Congress put the deadline into the text of the amendment itself. And so arguably it was part of the thing that the states ratified, and that's why Congress would really would be overstepping its power to then change it after some states ratified it. But putting it in the preamble, I think, does make a difference to that. More importantly, though, the language of the deadline. So Prohibition Amendment, the deadline says that this article shall be inoperative unless ratified within 7 years. So inoperative, dead, unless ratified within 7 years, right? There was a point at which Congress decided to start putting that deadline into the text of the preamble rather than the amendment itself. And they did that with the 23rd and 24th amendments. But even in those preambles, the language was still sounded like dead if not ratified. It said only if ratified, valid only if ratified. The ERA deadline, as you saw on the slide that Professor Langvard put up, says shall be valid when ratified within 7 years. So inoperative unless, totally dead. When ratified within 7 years means if you get it back within 7 years, it definitely goes in the Constitution. If you don't get it back within 7 years, it's late. Then we have to, it's not a question we have answered in advance. In fact, we postponed to a later time as to what to do if you take longer than 7 years. So I think both textually and just legally in terms of the placement, I think it's obvious that Congress has the power to revisit its initial calculation of time. And I think it's important though, all of the things I've said about what the ERA could do and mean in this historical moment that we're now in, that I'm sure none of the framers of the ERA predicted, the global pandemic and its effects on women. I think this is where it's actually really important to the legitimization of the ERA that Congress take action and create new legislative history through the process of hearings and floor debates. And we've seen some of that. That is, you see a strong record in the floor debates. In fact, the House actually voted last year already once in 2020 to remove the deadline. And so much of what was said in those short 1-minute speeches centered around issues of workplace inequality, unequal pay, pregnancy, unfair treatment of pregnant workers, and so forth. So we have that record from last year. Some of the themes, like the displacements caused by the COVID-19 pandemic, came up in the floor debates just 10 days ago when the House voted to remove the deadline. I am a little bit troubled by the fact that they bypassed the House Judiciary Committee markup process. I think that there may not be Senate Judiciary Committee hearings. I think that the procedure that they've used in the Senate right now is to bypass the Senate Judiciary Committee. I think that's a mistake. I think the hearings are needed to create an updated legislative history, because without that updated legislative history, all we have is fairly abstract text. Equality of rights under the law shall not be denied or abridged on account of sex. And if you hand that text to judges, they'll use whatever interpretive tools and vision of gender equality they prefer, rather than something that's anchored in the original public meaning. And when I say original public meaning or the framers' intent, I think there's a 50-year ratification window. So everything from 1971 until now would count until the thing is definitely legitimized. So, so I'm hopeful that there will be more opportunities for hearings by which public meaning can be made. I think that's critical to ending up with an ERA that's actually worth having. But I think there are some dangers that if we don't do that work, if we don't pay attention to the process by which the ERA is legitimized, then it does get handed over to judges, and judges could interpret it to mean strict formal equality, no affirmative action for women, strike down the law that requires at least one woman on a corporate board of directors that California adopted, right? And I think if the supporters of the ERA don't want that to happen, then it's important that they are vocal about what they intend to overrule that exists in existing Supreme Court case law, say around congressional power, and what they intend to make clear with regard to how this amendment is going to do something differently from the Equal Protection Clause that we already have around gender. So why don't I just stop there? I think I've gone on longer than I was supposed to.
Great, thank you. I'm actually going to pick up right where Professor Suck left off, I think, but I want to start by saying that I'm the old lady on the panel, and I'm old enough to have spent the first part of my college experience working very hard to pass the ERA. I was chairman of the ERA action team. I spent every vacation at the National Organization for Women trying to raise money. I sent canvassers to Illinois and Florida in vain. So the amendment and the words are indelibly like etched in my brain and will be forever. Equality of rights shall not be denied or abridged. But either in, the cynicism that's grown in me after 35 years, or too much reading of equality jurisprudence, I just worry that focusing on equality, that using an equality lens to think about the problems that women face right now, I just question whether that's the right thing to do. So I am in almost complete agreement with Professor Suck that we need to enrich the public understanding of what gender equality might mean under the ERA. But what I want to warn against is what actually it might look like if we don't have a rich enough discussion, rich enough sort of, I want to say, constraints on what courts might do in interpreting the language of the ERA. And I think the reason we need those constraints is because I think we are as confused today as we were 35, 40 years ago on what sex equality means, what sex equality allows and what sex equality requires. And I think if you look at the Supreme Court jurisprudence, and admittedly, it's all 14th Amendment jurisprudence, and maybe it will be different. Like maybe they will see the ERA as doing something substantially different. I'm not altogether confident of that. But it's very clear if you look at the sex equality cases that the court views sex equality and race equality differently. The court has been quite clear in the racial context that racial injury, the injury against which equality is supposed to protect us, comes from gender's distinction, comes from what Justice Harlan identified in the dissent in Plessy v. Ferguson, which is that everybody knows that the reason we make distinctions on the basis of race is because it is a way of creating a subordinate status, right? Because it is a way of making one class of people inferior. And everybody does not know that about gender. They didn't know it 50 years ago. They don't know it today. When you walk into Macy's, which you used to do, and presumably people will do again, in a couple months, and you see women's clothing on the first floor and men's clothing on the second floor, you don't say, oh my God, that is so offensive, right? And if that's not so offensive, if that distinction isn't so offensive, what is the harm from discriminating that comes from discriminating between men and women? So the way this often manifests itself is around questions of choice, which has been a sort of discourse through feminist movements forever, right? There is, so if you look at actually what happened with Phyllis Schlafly in the 70s and 80s, right? The rhetoric from the Schlaflyites was, they're going to take away your ability to be a homemaker. They're going to take away your choice whether you want to spend time with your children. They're going to take away your ability to take your husband's last name or give your kids your husband's last name. They're going to take all that away from you. And the response was, no, 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 no. This is about choice. What we want to do is give women choice. But part of the problem, right, is when we say it's all about choice, then we confront a real world in which women actually have very, very different views about how they want to live a life of gender equality. Okay, so I want to talk just briefly about two cases. One is Hogan v. University of Mississippi, which involved a all women's nursing school and was challenged in Ruth Bader Ginsburg fashion, though not by her, by a male plaintiff who had to drive 30 miles to go to nursing school, and his next door neighbor got to go like 3 blocks to the nursing school because she was a woman. And in a 5-4 opinion, note the difference between Brown v. Board, which was 9-0, right? In a 5v4 opinion, Justice O'Connor says stereotypes are the problem. The stereotypes created by an all-women's nursing school ultimately hurts women. It's curious because like it wasn't actually a woman who was complaining, it was a guy who was complaining, right? And Justice O'Connor said, but the problem here we have to address is that these stereotypes could hurt women. The dissents said that actually they thought that oftentimes sex segregation was a reflection of women's preferences, not something that was imposed on them. And they were at a loss, that's a quote, as to why an equality mandate should force women to do something they don't necessarily want to do, okay? I think that debate is still alive and well. If you think about what has happened with COVID, if you think about just this massive, massive gender differentiated response, right? Consequence to COVID, right? It's all about women taking primary responsibility for children. That's like, it's not much more complicated than that. Like, that's what it's about, right? But if you ask the vast majority of those women, whether at some level it was volitional, whether they wanted to take the lead in taking care of their children, the vast majority say yes, right? That's what they wanted to do. And so what do we do about that? I am all for like giving those women more money. I think that one of the sort of hidden gems of the child payment, child tax, whatever we're calling it, that just passed, all that money is going to women, right? I mean, it's going to families if there are 2 parents there, but it's all going, but for every family that's headed by just a woman, which is a huge number of single parent families, right? That's going to women. That's a great thing. But to me, that's a policy choice that is made sort of outside of an equality lens. And I actually worry about what happens if someone starts putting real equality pressure on some of what we need most, which is, you know, more money for women in all sorts of ways. Let me speak for a second about what VMI actually says about that. So I actually find VMI a curious opinion because Justice Ginsburg says, interestingly to me, she doesn't focus on stereotypes as being the problem. She doesn't talk about what Hogan talked about. She talked about how important it is to protect the woman who can actually compete at VMI. But she also says that integrating VMI will unquestionably require certain forms of segregation, separate dorms, separate physicality requirements. It will require a kind of separation that we would not possibly consider in the context of race. Separate dorms, separate physicality requirements. Justice Harlan and Plessy would rightly say that's just some sort of badge of inferiority. We don't want that, right? I think what Justice Ginsburg was concerned about doing is, again, a policy goal that I absolutely share, which is trying to open up the door wider and encourage more women to go to VMI, which you can do if you actually change the physicality requirements, which are kind of stupid because who needs to do chin-ups anyways? But the point is, right, that's a sort of, it was a nice turn that she made there, right, with regard to what equality might require. I like it. I'm not sure that's the way everybody views equality. In particular, there is a, to me, dangerous sort of coming together between what I would call relatively far left gender theory and the current Supreme Court. So when Professor Catherine Franke says the purpose of anti-discrimination law is to tear down anything that makes coherent the notion of male and female, right? That the problem is we make that distinction at all. She sounds a lot to me like Justice Gorsuch in Bostock, and this gets to Professor Langford's third question. She sounds a lot to me like Justice Roberts in Parents Involved, when he says, hey, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, which is a way of striking down a voluntary busing program, right? If the problem is, if the problem of gender inequality is actually we have tried to make coherent a category of male and female, I don't think we will have the kind of legislation that Professor Sook was asking for that I would absolutely support, but that I think is not particularly well settled in how equality has been interpreted by courts. And so actually, I hope I also kind of answered Professor Langford's fourth question, which was what happens to strict scrutiny and all here? I think strict scrutiny would be kind of a disaster. So if nothing else, the public discourse and the public meaning making around the ERA before it's actually passed needs to say that. But even if it says that, I do worry that it actually won't even have the popular support that it needs unless from the beginning, we understand this amendment to have a very capacious understanding of what equality might mean. And I will end there to leave some time for questions.
Great, we have a few questions. And actually, Professor Baker, you answered a question about Phyllis Schlafly's objection. She was kind of the voice of objections in the 70s. Another of her objections had to do with the draft. And one of the questions was, would subjecting women to the draft help or hinder the ERA initiatives? Does anyone have thoughts on that?
Sure, if I could address that. So I'm sure some of you know that there's a CERT petition that the ACLU is teaming up with the National Coalition for Men. And they're challenging the selective registration, the selective service registration statute, which now just requires men to sign up, even though there has been no draft since 1973. But in case we have one, men have to sign up, but women don't. And of course, Phyllis Schlafly said women would have to be drafted. And there was not much agreement amongst the ERA proponents on this question in the 70s. Some of them, like Patsy Mink and Shirley Chisholm, were pacifists and very against the Vietnam War. And they said, if you actually got the ERA, it would probably cause Congress to get rid of the draft because it's a privilege that women have to avoid the draft that would have to be extended to everybody equally. And so I think there's a whole range of different, and of course, one interesting question is, if the Supreme Court takes the case, will they respond by saying women have to register, or by saying that nobody has to register? But I think this is also the kind of problem that Ginsburg in some of her scholarly writings was concerned with in the 70s, which is linked to my legislative understanding of the ERA. The idea is that judges don't feel, they could just declare that it's not consistent with equality, whether under equal protection or under the ERA, but it's really a legislative choice as to whether you move in the direction of like making everyone register versus making nobody register and moving more towards a pacifist and demilitarized outlook. And I just want to say, I share a lot of Professor Baker's concerns. I think as law professors, we're always sort of moving between the space of prediction and the space of normative, I don't know if advocacy is the right word, but just having a normative outlook about the law. So I think on the one hand, the cynic in me says, all of these ideas are just, these judges, these guys in Congress, it's not going to happen. So why bother? But I also just think that, we are in the process now. And it can happen, like, it's not going to happen if no one tries to make it happen, for sure, if no one wants it to happen. So we could be sure that it's not going to happen if we start from the place of cynicism and stay there. And I think some of my optimism and my more capacious understanding of the equality frame, I think comes from my work as a comparative constitutional law scholar. I came into writing about the ERA not from US constitutional law, but from comparative constitutional law, where many countries have had provisions, equal rights between women and men, adopted simultaneously with provisions that say mothers deserve the special protection of the state. And they were seen as being of the same cloth, not in tension with each other. And I think that is a view of equality that it may not have taken hold in the US, but is very common in the rest of the world of constitutionalism. And I think we have an opportunity to engage with that right now.
Thank you.
I want to say one thing about the draft, if I could.
Sure.
I actually think that this is an example of how sort of culture has changed, notwithstanding the absence of an ERA. I think the draft would have been a big problem in the 70s. And I think that a ton of people now would just say, yeah, that seems fair. Like, like it doesn't really, it doesn't have the sort of horror factor that it had in 1974. There are a gazillion more women in the military anyway, right? As it is, the combat restrictions are mostly gone. Most of the military wants those restrictions gone now anyway. I think it's kind of a, I can see how for some small portion of the population, it would be something to get riled up about. But I think most people would say, yeah, it's just unfair. And I think it's actually important that we do that stuff, because the little pieces of paternalism that are left don't do women much good. I don't think that support for mothers or, support for caretakers is paternalistic, but I think the draft thing is paternalistic. And I think it would do us good to do some sort of hard work of figuring out what's important to make a distinction around and what's not.
We are at time. I'm just bringing that up in case anyone has constraints, but I did want to ask one final question. There were a couple of questions relating to the term sex rather than gender orientation. And if the panel, if someone could address that distinction. And again, I think that's something that's very different now than it was in the 70s. So if someone could answer that briefly, I'd appreciate it.
I think the brief answer is we don't know. I think this would be yet another reason for everything Professor Suck was talking about, right? So we can we can have a foundation that courts can use to interpret what this might mean. I do think that they would just sort of adopt the Bostock reasoning to this, but I don't know Yeah, I think that would be the first take, but I don't know. Maybe other people feel differently.
So my answer is the same as my answer to a lot of the questions that are contested and ambiguous. I think this is why creating a legislative history helps. Sex meant something. It meant equality between women and men in 1972. I think that now, I mean, we have a legislative history on the Virginia floor. Danica Rome, the first transgender delegate in Virginia, got up and said, today in 2020, when we say equality of rights unabridged on account of sex, we know that if you target someone because of their gender identity, it's because of sex. That's how we understand it in 2020. And I think it's not just a kind of textual exegesis of the kind you see in Bostock that brings us there, but politics, the politics of making an amendment and legislative history, and that takes us to that meaning.
Great. Thank you so much. So there was a post by Professor Sook about her book and some articles related to our conversation here this evening. Obviously, this is a huge topic. I'm so pleased that you all attended, and this is a wonderful panel. Thank you so much for your expertise and your discussion of this topic. Have a great evening, everybody.
Thank you.
Yeah, thanks.
Thanks.